Welcome back to this course on copyright and related rights law. This week, we are looking to understand performers' rights. We have already seen statutory definitions of performance in different acts in different parts of the world. We have also seen the distinction between works and performances. In the previous session, we looked at what are performers' economic rights. In today's session, we are going to focus on the moral rights of performers. Let us, before looking at the specific moral right provisions within the Copyright Act, let us take a look at whether works which have been used in a performance are in fact severable in terms of the connection it has with copyright. You would recall we had a similar discussion with respect to composite works when we had discussed Section 13 of the Indian Act. We had discussed how even if a cinematograph film or a sound recording were to be considered as works in which copyright subsists, it would not affect the separate copyright in the underlying works. Similarly, in Section 39A, the second clause, it states that performer's right shall not affect the separate copyright in any work in respect of which the performance is made. Therefore, just because a performance carries a particular work, it does not mean that there is any kind of ownership that the performer can claim on the content itself. Always remember that the content is a work for which there is an author, and that author is exercising rights under Section 14. Can it be possible that a performer can own the content? Yes, it can. But that will be based on how that transaction has occurred. Has the author transferred the content to the performer? If yes, then the performer can control the content as well. Otherwise, the performance and the content, these are severable. With respect to moral rights now, we must first understand that just like performers' rights, which are economic rights, were introduced much later into the copyright framework in India and other parts of the world as well. In India, they were introduced in 1994. But at that point, when such rights were introduced, moral rights were not introduced. Moral rights were introduced only in 2012 with the 2012 amendment to the Indian Copyright Act. The fact that there is content which a performer performs, and that content is a work, would mean that both the work and the performer enjoy moral rights over their own specific expressions. Which is why it is important to understand that just because there is a performance on a content, it doesn't reduce the relevance of the author's connection to that performance. Authors too have moral rights, and the moral rights of authors have been taken up in judicial considerations on several occasions, and which is why that is a deeper study. A foundational distinction based on theory between economic rights and moral rights is also something which we will take up later when we are looking at economic rights and moral rights of authors in more detail. In today's session, we are simply going to make a brief distinction between economic rights and moral rights, and that distinction is that moral rights have the justification for moral rights for performers or authors in very brief terms is that certain rights are claiming their origin in terms of a natural existence. To explain this, let us understand that when an author creates a work or when a performer creates a performance, a part of that author or performer is getting attached to that expression. In other words, a person's personality is reflected in that particular expression, which would mandate then that because there is a bond between that expression and its author or its performer, that person should be readily acknowledged for that expression. Also, that any kind of damage which usage would pose to reputation of such a performer or author should fall within this natural realm. But more on this later. Let us focus on the provision itself which talks about moral rights of performer. Let us look at section 38B. 38A, you would recall, we had discussed with respect to economic rights. 38B states moral rights of the performer, and it says the performer of a performance shall, independently of his right after assignment, either wholly or partially of his right, have the right, and then it prescribes what the specific moral rights of performer are. But before we look at those specific rights, let us focus on the language in 38B, which states that independently of his right after assignment. What do we recall about assignments? We recall that when an assignment is made by the right holder, ownership over that particular right is transferred to the assignee. This is different from licenses because in a license, no such transfer of ownership occurs. Therefore, when an assignment occurs, say for example, the performer is the assigner, then the assignee becomes the owner of the right, and no claim in economic rights can be claimed by the performer. What section 38B is saying is that the moral rights that have been prescribed under 38B will exist despite an assignment having taken place. On that point, because we are looking to understand what an assignment is and what it would entail, let us look at what is the format of an assignment that has been provided within the Copyright Act. What this will help us understand better is how transfers of ownership can happen in cases of performances. And once we've understood that, we will then come back to this provision on model rights. Let us look at Section 39A of the Indian Act. It says, certain provisions to apply in case of performers' rights. It says, Section 19, Section 30A shall, with necessary adaptations and modifications, apply in relation to performers' right in any performance as they apply in relation to copyright in a work. Let us understand that majority of the provisions within the Indian Copyright Act are concerned with works. In fact, in Section 39A, the provisions I have cited, 19 and 30A, are only two of the many provisions that have been inserted within 39A. The Parliament has thought it fit to not repeat provisions which are otherwise with necessary modifications applicable to performers. And therefore, two very important provisions, Section 19 and Section 30A, with modification is applicable to performances just like how they are applied to works. What is Section 30A? Section 30A is saying that the provisions of Section 19 shall, with any necessary adaptations and modifications, apply in relation to a license under Section 30 as they apply in relation to assignment of copyright in a work. Section 30, we have discussed earlier as well, is a provision that refers to licensing. Section 30A, on the other hand, is saying that the modality for assignments that has been laid out under Section 19 will, with modification, apply to licenses. And therefore, Section 19 is of a lot of importance for all of us, because Section 19, which lays out this modality, is not only applicable for assignments but is also applicable for licenses with respect to performances. Let us then understand the components of Section 19. Section 19, the title of this is Mode of Assignment. Section 19 clause 1 says, no assignment of the performer's right in any performance shall be valid unless it is in writing, signed by the assigner or by his duly authorized agent. When we read Section 19 provision, wherever it says assignment, you can also read assignment as license. Please keep that in mind. Second, for the purpose of convenience, I have replaced wherever necessary author's right and work with performer's right and performance. In understanding these provisions, you can also understand that these provisions will be applicable with respect to works as well. There are many occasions in the professional life of creative professionals that they may be faced with a situation where a person is telling them to incorporate their expression in a larger work, a composite work, without any agreement. When I say without any agreement, I say without any written agreement. You can see that in order to protect the interest of authors and of performers, it is mandated under Section 19 that any such transaction must be in writing and it must be signed. According to this provision, if no such written agreement exists, then such an assignment shall be invalid. Let us look at the second provision. It says, the assignment of copyright in any performance. We can read this as the assignment of performer's right in any performance shall identify such performance and shall specify the rights assigned and the duration and territorial extent of such assignment. It is saying that there must be clarity in the written agreement on what performance is being assigned. Not only that, it should also clarify the duration and territorial extent. What does that mean? We had understood that be it a license or an assignment, because the right holder is the one who is initiating the transaction, he has all the right to restrict that usage in duration and in territorial extent. Meaning, the right to issuance of copies, for example, to a particular assignee can be restricted to 3 years. The duration, the territorial extent for which the assignee has the right could be 2 states in India. This is up to the right holder to decide, and upon negotiation can therefore be modified. Let us look at the third provision. It says, the assignment of performer's right in any performance shall also specify the amount of royalty and any other consideration payable to the performer or his legal heirs during the currency of the assignment, and the assignment shall be subject to revision, extension, or termination on terms mutually agreed upon by the parties. This says that the amount of royalty, you will recall, royalty refers to future payments. The amount of royalty which a performer will be eligible on account of the use of that performance must be clearly specified in the written agreement itself. It is also stated that the assignment shall be subject to revision, extension, or termination on terms mutually agreed upon by the parties. This is a reference to that effect that the assigner and the assignee, the performer and the person to whom the ownership is being transferred, upon mutual agreement, they can decide how questions of revision, extension, or termination will be decided with respect to such an assignment. Therefore, it could be possible that the nature of the assignment and such a transfer will require the least amount of intrusion into the assignee's enjoyment of his right, and therefore it could be possible that the performer is engaging in an assignment agreement which seems one-sided. And that is something which is permissible under this particular provision. Let us look at the next provision, which says, where the assignee does not exercise the rights assigned to him under any of the other subsections of this section within a period of 1 year from the date of assignment, the assignment in respect of such rights shall be deemed to have lapsed after the expiry of the set period unless otherwise specified in the assignment. What is this provision saying? If there has been no exercise by the assignee of the rights that have been assigned, if the performer has assigned issuance of copyright to a particular person and within 1 year no issuance of copies has happened, then such an assignment deed will be lapsed. In other words, the right to issuance of copy will come back to the performer. But this is subject to a limitation which you can see in this provision, which is that if in the assignment deed it is clearly provided that even if the assignee does not issue copies within a year, then it will not lead to a lapse of the agreement, then that is something which is permissible and it will not lapse. Let us look at the next provision, which says, if the period of assignment is not stated, it shall be deemed to be 5 years from the date of assignment. As we had discussed, in a written agreement, all considerations pertaining to that particular assignment or a license must be mentioned. And one very important consideration will be, what is the time period for which the agreement will be in place? What this provision says is that if no duration has been prescribed, then it will be taken to be a period of 5 years. The next provision is that if the territorial extent of assignment of the rights is not specified, it shall be presumed to extend within India. Because performer rights are rights which can be exercised across the world, unless it is specified to what extent does the assignee gain a particular right, it will be India. Now that we have understood the effect of an assignment and how this assignment deed must be framed, let us now come back to moral rights. You will see what this provision 38B is saying is that even if there is entire control of a performer's right that has been given to another person, this control by another person will not take away the moral right claim of the performer. That will remain. Let us then look at what this moral right claim is. The first claim is that to be identified as the performer of his performance, except where omission is dictated by the manner of the use of the performance. What does this mean? Every performer has the inherent right, irrespective of any assignment, that when his performance is used, he should be acknowledged, credited, identified for his performance. We have all seen films And in films, when the content of the film is all finished, we can see credits roll. In these credits, you must have seen acknowledgement of all the performers who have contributed their expressions to the film. At the starting of the film also, it is a practice to give due attribution to the most significant performers. The principal actors, for example, get attributed right at the beginning of the film. But there is an important limitation you can see that is present with respect to this right, and which is, except where omission is dictated by the manner of the use of the performance. This exception can be taken to mean that if the format of usage of a particular work is such that giving attribution or identifying the performance is impractical. What could be such a situation? There is not much clarity within this provision itself as to what such a situation could be. Because such a situation has also not been raised before the court, it is not clear what is the scope of this limitation. But one thing is certain, that this is a perception of the industry. Therefore, certain kinds of usage which in the industry understanding makes attribution impractical, then such an attribution may not be made. But what exactly could this be is not something which is very clear. Let us look at the second right. The second right is to restrain or claim damage in respect of any distortion, mutilation, or other modification of his performance that would be prejudicial to his reputation. Let us look at some of these terms. To distort is to give a misleading or false account or impression of. Mutilation is to inflict a violent and disfiguring injury. Reputation is the beliefs or opinions that are generally held about someone or something. Imagine a performer who has delivered a performance keeping in mind a particular script. But say, the script is altered in such a situation that the performer, had they had access to this modification, would never have agreed. It could be something vulgar. And therefore, any such misleading impression, or in other words, distortion. What about a situation where the performance itself is disfigured, say with some kind of an alteration? A performance, after all, is being visually perceived by the audience, and therefore any visual editing to what was otherwise performed through morphing, for example, would be something that would be captured within this provision. What this provision states is that such a modification, such a distortion, or such a mutilation should be prejudicial to the reputation of the performer. Reputation, as we can understand, is the belief that is held by the public for such a person. And therefore, it's a question of whether the public will perceive this particular act done on the performance to be prejudicial to the performer's reputation. In this provision, there is also an explanation. This explanation reads, "For the purposes of this clause, it is hereby clarified that mere removal of any portion of a performance for the purpose of editing or to fit the recording within a limited duration or any other modification required for purely technical reasons shall not be deemed to be prejudicial to the performer's reputation." It is a practice in the film industry, for example, that performances which were otherwise captured for the purpose of the film would undergo cuts. And these cuts, as has been mentioned in this explanation, could be purely for technical reasons. And these cuts are not going to be considered as prejudicial to the reputation of the performer. This is what this explanation says. It prevents this provision from being used against technical practices that are being followed in the industry, and therefore is an important exception to the right granted against distortion, mutilations, and modifications. At the end, let us look once again to section 2QQ and its proviso. We had discussed that certain kinds of presentations will not be considered as performances. The proviso to section 2QQ states that where a presentation is casual or incidental in nature and in the normal course of the practice of the industry would not be credited, then it is not a performance. But what is important for us is the last line. It says, except for the purpose of clause B of section 38B. Even though an extra or a junior artist and their performance will not have any economic rights, will not have any identification right as a moral right, such an extra and such a junior artist will still have the right of 38B clause B, which is the right of integrity. No such presentation, whether by a performer whose performance has economic rights or by a performer whose performance does not have economic rights, is without the protection of 38B subclause B. That is, that presentation cannot be used in a way to prejudice his reputation. With that, we will close this understanding on moral rights. In the next session, we will look at the distinction between performer rights and personality rights. Thank you for joining me. See you all in the next session.